Hi, this is Mark Lindsay with ECG, and this is just a quick note about some of the rulemaking procedures that the FCC is going through that have some insights for engineers, technicians, and leadership who are implementing the shake and stir framework for fighting robocalling. So this was a notice of proposed rulemaking, and we're going to be covering it in the upcoming training class, the ECGT 5020, where we cover regulations for engineers and technicians, those who are building out the voice and video and meeting networks. So there's a few things that I thought were really interesting from this, 5 in particular. I'm just going to touch on briefly. One was that the FCC called out how the new Traced Act that was passed in December 2019 actually regulated one-way communication. So when you say Alexa call grandma, then that's a good example of the sort of one-way communications that they're talking about, because it may be making a call to the PSTN. So that's a new thing, and there are potentially rules around the implementation of shake and stir for robocalling protection for services that involve those one-way calls. So what about your out dial from your conferencing system? What about your video meeting board and things like that that have the ability to place an outbound call to bring somebody into the call? That's an interesting space. You need to watch that when you're doing your implementation to be sure that you're following the law. Another thing is the intermediate provider requirements. They were not really specified super clearly in the law, but in order to make it make sense, we really need the intermediate providers. Those are basically, if you've got A and Z here, then they're all the folks in between. So all the providers that are neither the originating company or the terminating service provider. So those intermediate providers need to be involved with the shake and stir. So they need to pass along identity headers when they receive them. If they don't get an identity header, then they need to add one on, a C-level attestation, which is kind of a low-level attestation, but at least it's something that identifies where the call entered the shake and stir compatible part of the network. So that's another kind of new proposed requirement that they're creating here. Another question that they're raising that it's an interesting and intriguing issue the FCC raised is circumventing shake and stir by using non-IP networks. So if you're routing a call out to a TDM network and then back in, potentially you could use that. And the FCC wants input on how to prevent circumventing the whole system by using these TDM networks. Unfortunately, the state of the rules in the U.S. kind of makes it difficult for a lot of providers to transition to IP-based networks. So there's some rules and some fees and costs that are associated with that transition from TDM to SIP in particular. There are a lot of TDM networks out there operated by a lot of small providers, and so nobody wants to see those guys get exploited as a mechanism to bypass the shake and stir implementation goals. Another question they raised was this prospect of monitoring compliance. So maybe if you're placing outbound calls, you need to confirm that your identity headers that you've signed to attest to your right to make a call from a telephone number, you need to confirm that those identity headers are delivered all the way to the endpoint. So that's another kind of question that came up. Do we want to mandate some sort of monitoring for compliance, maybe either through contractual agreement or potentially through doing some actual testing? It's an interesting question that kind of comes out of the implications from the Traced Act that was signed in 2019. And then kind of a final interesting point is, how do you know when you've begun implementation? There are some dates and deadlines. Service providers are going to need to move pretty fast in order to meet these dates and deadlines that are actually required of service providers. And so how do you know when you've begun? So under the law, you have certain dates by which you have to begin the implementation. So the FCC is kind of proposing, well, at the point when you've got a single component of your network, a single session border controller maybe, or a single switch, which would probably mean an application server in your network, when you've made that component capable, so either you can do authentication or verification potentially on that one device, that may count as having begun the implementation of the shake and stir framework for regulatory purposes. And so you might see cases where you really want to prioritize a partial implementation on a single part of your network. Of course, I'm not an attorney, I'm not a lawyer, and so you're going to want to get legal advice from actual lawyers. I'm here to help you with running the technical sides of your network.